All right, hi everyone. Shh. Well, how's everyone doing? Louder? Good to hear it. Welcome back. You had a long weekend for me. I promise it won't happen again. It's a nice gap. We won't see you for a full week, but it's good to be back. Anyone do anything fun this weekend? Anything fun for Labor Day? Nothing? Nothing. No barbecues? No one? Fish fry?
Yeah, we took that a little bit.
Yeah, good. At least some of you did. Good. You should. And you have to enjoy yourselves a little bit. I know it's difficult, but there's more to life than law school. But now you're stuck here. So, any questions on what we did last week? Last class we talked about, remember the haunted house and latent defects and leaky roofs, and what kind of remedies can be had in those cases. All right, so any questions about that? Okay. So today, this is the last topic of that was called the contract of sale. And this one rounds out things which might not seem very property related, but they might seem more actually tort or contract related. Specifically, what happens if you hire a contractor to make repairs on your house, and then you sell your house, and then a couple years later you find out that the repairs were bad, right? These are kind of cases where you have to test how much liability we're willing to impose on contractors for subsequent purchasers. We also talk about what happens when a contract of sale goes wrong. That is, where parties agree to buy a piece of property, and then one party backs out, right? When the buyer backs out and the seller is forced to sell it at a lower price, who's liable for that? We'll get to it. Also, generally the buyer, you're right. Also, we'll do another case where what happens when the buyer backs out, the house is resold for the same amount of money, and the buyer wants his deposit or earn his money back. We'll also discuss cases like that. These will round up all the different issues, I think, that you'll probably encounter with sales of property. Okay? Any questions? Okay. All right, so first we're going to talk on something that you probably covered in contracts. Let's see. Is that Daniela? Okay. I have the seating chart here. There are about 4 or 5 you didn't put your names on here. I don't know who they are, but I know I'm missing about 4 or 5 names. So if you can come up afterwards, then please put your name on, or if I call on you, you don't know, I will add it here. But please, let's try and keep the seating chart fixed. Okay, so Daniela, do you remember in contracts what an implied warranty of quality or merchantability or something like that? Do you remember what that was? Sorry, louder, I can't hear you.
It was a warranty that you were like if you got with your product, if you know, if something happened to it.
What's a warranty for?
For repair.
Not exactly. Oh, implied warranty of quality is, pardon the expression, implied warranty of the quality of the product, right? An implied warranty guarantees certain aspects of the quality of the product. Well, let's break it down. Zuge?
Yes.
What does implied mean? What does this word implied mean? I think we've done this in a couple other contexts.
Not expressly, but it's there.
Okay, so do the parties have to actually make an agreement about an implied warranty? No, they don't. Where does the agreement come from that the parties don't make it themselves? Let's see. Alex, where does this warranty come from if not from the parties? Implied as a matter of law. Alex, what does that mean?
If you're selling the shirt, you don't need to expressly say shirt's on a car. If you're a car salesman, you don't need to expressly say the car is good to drive, because as a matter of law, it should be.
What does a matter of law mean? What does it mean as a matter of law? Use that phrase. What does that mean? Oh, so you've all used that expression, never actually defined it, right? Okay, let's see. Stephen, what does that mean as a matter of law?
It means that there's no
express agreement by the people in privity under the contract.
Uh-huh.
The law itself deems there to be a certain warranty.
Who is the law, or what is the law? I go like Bastiat.
What is
Yeah. Where does this law come from? Where does this imposition of law come from?
They say it all the time.
I know they say it all the time. People don't stop and think about work. Yeah. That's Garrett.
It can have multiple sources. It could come from the judges who
Okay.
show it through common law, or it can also come from the statutory
Yes.
UCC.
Yes. Every common law case you do, where court says, as a matter of law, so-and-so, that means the courts say it's that makes it law. The courts, over the course of many years, have implied warranties in different products. Before we get to the UCC, we'll talk about the UCC in a moment. But courts said basically this: even though a contract might not have this term, this contract is so important, this term is so critical, that we will read it into every contract. When a court implies a warranty as a matter of law, imagine every court taking a red pen, right, and scribbling it into the contract after the fact. That's what it means to have a warranty implied by law. Every contract, as a matter of law, is presumed, or let's pretend. We pretend that term was in there. So as a couple of you guys said, there's no necessary to bargain away with this, right? So is that Blaine? Blaine, what happens? Can the parties contract around it? Can the parties waive an implied warranty of quality? If the parties say, "Nah, I want to buy cheap, shoddy goods," can they do that? Can the parties waive an implied warranty? No, why not?
Because it's, I guess, assumed that the product is going to
Why can't the parties waive it? Who imposed it? Law. You can't get around the law. You can't beat it. You cannot waive an implied warranty. You can't say, you know what? I agree to buy this shoddy piece of property. Okay? Is that David?
Yes, sir.
David, why do you think it is that the courts don't let people waive these warranties? Why do they know better than us?
Well, it's against public policy.
Oh, okay. Okay, now we got it. What do you mean it's against public policy?
You want people to have faith in the products that they buy.
So what if people agree? So you know what? I don't have a lot of money. I want to buy this cheap piece of crap, right? I want to buy a cheap good. Why don't we let people do that?
Well, we want to protect their interests in their property.
Okay, good. So it's about protecting people. It's actually somewhat paternalistic if you think about it for a second, that you can't opt out of it. We're saying we as a society, public policy, the courts, right? We're deciding that no one should have any goods of such low quality. So as a matter of law, we will impose this term in every contract. We will write it in and pretend it's in every contract. And say someone thinks they know better than us, they want to try and contract around it or waive it, no good. You can't get around it. You can't stop us, right? This term has to be in there. Everyone see that? Okay? The entire idea of an implied warranty is that the courts impose it as a matter of law. The courts say, as a matter of public policy, every contract must have this term. You can't contract around it. And it's there. This is the basic, the bare minimum that every commercial transaction must have. Okay? Everyone see that? Any questions on that? Now, I think Garrett was correct. He said that usually these are imposed through the courts. Historically, that was true. But in the 20th century, we have a lot of implied warranties by statutes, by things like the Uniform Commercial Code, UCC, which you study in your contracts class. There have been a lot of implied warranties imposed, and we'll talk about a couple of them this semester. But historically, these were done by courts. Okay? So let's go back. Is that Claire? Claire, tell me, what is this implied warranty of quality? And use the word we just discussed before, but what does this implied warranty of quality mean?
It is the warranty that is taking place after a sale.
Okay, what does it protect?
The buyer.
No, I mean what's it a warranty of? What does it insure?
The property, the
Uh-huh.
defects. It protects the buyer of the possible defects.
Okay. The implied warranty of quality sets a bare minimum level of quality that you can't fall below. Whatever you're doing, whether it's a repair or a construction job, whatever, it has to meet some minimum threshold, right? Some minimum level of being good. If it's below that, the implied warranty of quality kicks in, and there can be a law, right? All right, so generally, has anyone ever worked with a home improvement contractor and they didn't do a good job? Anyone have any experience with that? Yeah, tell us about it. That's is that Mike?
Yes.
Yeah, tell us about it. What happened?
Well, yeah, I've been on both sides of it, where there's someone that,
Tell us. All right. Tell us your side.
well, we had some floors reinstalled in our house,
Mm-hmm.
and they cracked and chipped, and it basically just broke apart in like 2 weeks.
Uh-huh. So after they installed it, they broke apart.
Yeah.
Okay.
And it was horrible. Like, it was terrible.
Yeah.
I
So
couldn't walk on it.
so what happened? It's like walking on eggshells, right? Yeah. So what happened?
Well, threatened to sue, and they had to come back out and relay the floors. They had to buy all the materials out of their own shit.
Now, do you remember when you originally signed a contract with them? Was there any warranties in the contract that they would do a good job?
There was a warranty of that it would just that it would be. I can't remember the exact wording, but it was something that it would be functional.
Okay. All right.
Up to standard.
Okay.
Standard usage, I think.
Okay, good. So some sort of commercial standard of what a good floor would be, right? All right. So he was smart, right? He actually signed a contract, and they agreed to terms, and then they did a crappy job, so then he could threaten to sue in the contract, right? What happens if not everyone's as smart as Mike, and they didn't sign a contract? So they said, hey, buddy, you want to come fix my floor? It's like, yeah, sure, whatever, I'll come do it tomorrow. And you just handed him cash, and there was nothing said, right? Is that Michelle? In that case where there's nothing written, just you hand the guy cash, come fixes your floor, what's your backup? What's your only protection at that point?
I guess this implied warranty of quality.
Exactly. Why is it still there?
Because you don't need it with privity of contract. It's implied in law.
Okay, good. When I hire someone to do a job, and actually don't get the privity yet, that's not quite there. But when I hire someone to do a job, whether we say anything about a warranty, it's implied. So in this case, the Lempke case, right? They did some bad repairs. It would not have been any problem for the person who hired the contractor to sue him for this implied warranty. That's not an issue, right? If I hire someone and they do a bad job, I can sue them under this implied warranty and there's no problem, right? Kelsey? What was the problem then in this case? Why was there an issue about whether there could be a lawsuit?
Because they were the buyers after, like they were the next people to buy it. They weren't the original people who contracted with the people who built the garage.
Exactly. Subsequent buyers, right? So the issue here, right, is whether this implied warranty is available to subsequent buyers. By subsequent, I mean, actually, they won't say subsequent. I heard that before. That's a southern thing. Subsequent, right? Does this implied warranty, I love language is different, it's fascinating. Does this implied warranty apply to subsequent buyers? Okay, that was the issue in this case. So we have to explain a few concepts first, right? So someone said it before. Said Hugo. Hugo, what's this privity business? Someone mentioned it before. What's privity?
It's basically the contract between parties, I guess.
Okay, right. Privity defines a relationship, right? You remember the phrase privity of contract? Does that ring a bell somewhere in your fog from contracts last semester? Remember? Privity of contract means two parties are in a relationship, right? If I go hire a home improvement company to fix my roof, he and I are in privity, right? Whether or not we have a written contract, this implied warranty kicks in, and if he does a bad job, I can sue him on this implied warranty. The question in this case is what happens when there's a subsequent buyer. Now, traditionally, Stephanie, at common law, would the subsequent buyer have been in privity with the construction workers? How come?
Because the contract was just between the original buyer and the builder.
Good. Okay, so traditionally, at common law, there was no privity between the subsequent buyer and the construction workers, right? Why? They never made a contract. And let's just pause in this idea for a second, right? If you're a home improvement company, right, Rebecca, if you're a home improvement company, right, and you're making an arrangement with a party to do some repairs, does the identity of the party matter?
No.
Or does it? What do you think? If I'm doing some home improvements and I perhaps know the guy, well, that might make a difference in how I operate.
Well, you still have a duty to
Uh-huh.
act as a reasonable
What about maybe price?
policy. Yeah.
Like, explain.
Well, the first thing that came to my mind is, I mean, if you have a friend or you're well-known like bartering or something like that, you would hook them up.
Yeah, you hooked them up. No, that's exactly right. You hooked them up. So if I'm a contractor, right, and my friend asks me to do a job, he's like, listen, I don't have a lot of money, right? You know me, we've been friends for 30 years. Just do whatever you got to do. If you do a crappy job, I really don't care. I can't afford it. He's like, all right, I'll tell you what. I'll use some, used parts, whatever. I'll get it done for you. Promise me you won't sue me. He's like, dude, I won't sue you, I promise. That's not too implausible. I'm sure that there are people in this room who have really good friends who, if they ask them to do something on the cheap for them, they probably would, right? So if I'm a contractor and I'm making a deal with someone, I can take consideration who that person is. Okay, so now we flip it around, right? Now your buddy sells a house to someone else. You don't have that same relationship with the next guy. Whatever promises you made to the first guy would not have been made to the second guy. So you see the problem that emerges. If nothing else, you are now changing the dynamics in which people can negotiate. Because now, if I'm trying to do a favor for my buddy, I don't have to just think about my buddy. I have to think about the next home buyer, and the third home buyer, and the fourth home buyer. And this can go on for whoever knows how long, 20 or 30 years. So everyone see the general issue. Okay? Is that Mariah? Mariah, tell us, what were the facts in the Lempke case? What happened here?
So the buyers contracted to have they were going to build a garage.
A little bit louder, please.
They contracted to have a garage built.
Uh-huh.
And then after they had already purchased it, they discovered defects in it.
Okay, well, let's be careful. Who had the construction done? Which owners? The previous or the current owners?
The current ones, the subsequent purchaser.
No. Is that Stephanie? Mm-hmm. Who had the construction work done? Okay, good. The previous owners, right, had some work done. They had to build a garage. Okay, and then Stephanie, what happened after the house was sold? Okay, so keep the timeline, right? The first owners had this construction done. They had this garage built, right? The second owners, after they moved in, they discovered that there were some structural problems with the garage. The roof wasn't even. The trusses were blowing out. I understand that's like the actual parts of the roof were coming apart, okay? What kind of defect would this have been, Brooke? What kind of defect would we call this? Why is it a latent defect? Okay, good. This we did last week, latent defects, okay? Why is the busted roof a latent defect? Because there's no way to find out unless you rip up the entire roof, check the structural supports. At that point, you've already made a new roof, right? So there's no way of finding it, okay? So with this latent defect, there will be no problem if the first home buyer had sued, right? Had sued the construction worker. The problem is, can the second home buyer sue? There's a question here. Couldn't the second buyer sue the previous owners? They may have sued them for perhaps failing to disclose a latent defect, but it seems from the fact that they didn't even know about it, right? It seems that the construction work was done and they sold it within 6 months. They probably didn't even know. So I think they have to sue the construction workers. So at common law, right, or actually Lamar? So at common law, were you allowed to sue a subsequent buyer's contractor?
I don't think so.
How come?
Because you didn't have a contract.
Exactly. Okay. So at common law, it was impossible to sue the contractors for the previous owner because you weren't in privity with them, right? The contractors didn't know you, never made an arrangement with you. The subsequent buyers could not sue those contractors. Okay. So is that Heath?
Yep.
Heath, what did the New Hampshire Supreme Court here do with the common law rule?
They changed it.
Yeah, they reversed it, right? What did they change it to?
They said that you, well, I guess they obviously said that you could sue, and they kind of, I guess, merged tort and contract.
Good. Good. Okay. So this is a very good introduction to Property 2. Okay. What you're going to find in Property 2 as opposed to Property 1 is that a lot of tort and contract doctrine becomes folded in. Okay? What do I mean by that? In Property 1, property was almost entirely separate from... It's okay, you can come, you can sit. Don't worry about it. Okay, so in Property 1, torts and contracts were entirely separate. Property was its own law. But in the 20th century, there's been a strong move towards incorporating tort and contract doctrine. Okay? Why do you think that is? Is that Daniel? Daniel, why do you think it is that in the 20th century there's been this move towards having more tort and contract doctrine in property law?
A lot of changes in society. What somebody here says are increasingly mobile people.
Uh-huh.
You move in a short period of time, you don't have that much time to
Good.
discover all the problems of the house.
What is one thing, how do I ask this? Generally speaking, property rules are not fair, right? Remember what last semester you did, all the shifting executory interest and all the other garbage, where if you make like one wrong misstep, you lose your land? Or like if you don't enter by the right time, you can lose your land? Is this Tim? Are contracts and property, I'm sorry, are contracts and torts that demanding?
No.
What does contracts and torts doctrine kind of incorporate that was perhaps lacking in Property 1? What's that word? Come on, you know it.
Sorry. A little bit more passion.
Fairness.
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 Equity.
Empathy, equity, right? You'll find in your contracts and torts classes lots of things about fairness, right? There are different kinds of balancing tests. There are different competing interests, right? None of that's in property. Property is like if you don't enter at the right time, too damn bad, right? If you don't get your fee simple and you lose it. There's all these really harsh doctrines, right? If I, as long as I don't lie, I can stay quiet and you can buy the land. It's only been the 20th century that courts have started to read in or imply, right, as a matter of law, these doctrines. And the court's opinion here, if it sounds like they're all over the place, it's because they are. He's saying, well, there's some contract doctrine that's about fairness, and there's some tort doctrine about damages, and I think those would come really well together. So we'll make this like torts, contracts, property, Subway sandwich, right? And throw it all in, like, Jared will lose some weight, and then everyone will be happy. But what you've seen, and you'll see this a lot more, is that the 20th century has resulted in a wholesale change of property law. It's such a different class from this semester to last. You'll see it much more as we go on. But now you have courts getting in really strongly. Okay? So yeah, again, the doctrine in this case was kind of tort-like. Okay. So is that Trey?
Yes.
In what sense is this implied warrant tort-like, or like a tort?
Well, it's a matter of negligence as far as the way the garage is constructed.
Good, right. So usually you think of a duty, right? The contractor had some sort of duty of care to build it in a certain manner, and that seems like a tort doctrine, right? So if you hire a contractor who does a bad job, you can sue them for, some sort of tort duty, right? Kind of, right? Okay. Joseph, how is it kind of contract-ish?
This the whole fairness aspect of fairness of contract is always trying to get somebody back to where they were.
Yes, exactly. Make someone whole, right? Remember, that's the bottom line of contract. We make the parties whole. Restitution, right? So you see, they kind of merge the two, right? So someone did something wrong. Usually, is it Angela? Usually, what's the measure of damages for a torts? Well, usually it's your damages, right? Pain and suffering. What damages you actually occur? So if this were straight up tort, often the measure of damage would be: were there any leaks as a result of the bad roof, right? But in contracts doctrine, it's what you said. It's what's the measure of damage? Like, what's the value of the roof as good, and what's the value of the roof as it was built? And you remember, they subtract the two. So they've kind of even done a merger. So they've taken a tort, and they've assessed the measure of damage as how much it would take to fix and repair it. Right? It's an interesting doctrine that they've done this. Okay? So in the end, they abandon privity of contract. They abandon privity of contract. It's no longer necessary for the contractor, right? It's no longer necessary for the contractor to know the person. Merely doing a job puts you on the hook for liability with subsequent buyers, right? But for how long? Is that John? Yes.
I was curious about the contractors. I don't know, but do they have to have like some kind of certification or bonded, or anybody can be like, I'm a handyman, I'll build your house?
Generally, in most states, to be a licensed contractor, you have to have some sort of bonding. So you're saying if some schmo off the street, you might be in trouble if you're working with an unlicensed contractor. I don't think you have the same remedies. Because generally, it's an implied warranty of workmanlike quality, which is implied to licensed contractors. So I don't know if you hire some schmo off the street, they have the same implied warranties. Yeah.
Like a merchant.
Yeah.
I remember this Vegas, we had a similar conversation where they said if someone held himself out to be a professional in that field, they're going to be held to that same standard regardless of any certification.
Oh, if there's fraud.
Right.
Yeah, okay, so that's a different story. If you hold yourself out to be a contractor, then you actually will sometimes be held to that standard.
That's what
I thought you hire someone you know is not a contractor.
That's kind of leading to that. Yeah, that's
Okay, well, either way. But how long is a contractor on the hook for, Garrett? What, say I hire you as a contractor today, and then in 2015 I sell my house, and the house sold in 2017, and 18, and 19. House is flipped every year. And before you know it, there are 20 people, and you're still in business, right? How long are you on the hook for?
It depends on what would be reasonable for the expectation of how long the work would last.
Okay. This is the thing that the opinion doesn't really answer, and your answer was just fine. But the opinion doesn't get to it. How long is a contractor on the hook for? Because you can imagine you have a family business, right? And father and son contractor. They can be in the same business for 50, 60 years. Can you imagine after 60 years somebody coming back and suing, oh yeah, the house has been sold 10 times, fix my roof. So the court imposes a reasonableness standard. Is it reasonable? Right? Is it reasonable to hold this contractor liable? That's not much of a limitation in my opinion. But it's some sort of reasonableness period, so it's not forever. Okay? Yes?
Wouldn't it be best to impose some sort of, oh gosh, I forget the actual name for it, but it's like a statute of limitation, but it's for buildings, and instead of
It comes out.
Well, the court didn't want to set a number of years, right? Why do you think the court didn't want to set a number of years? Think about it. What's the inherent problem with these?
There could have been something that was a defect that didn't get discovered
Yes.
until after then.
Okay, and that's the rub. latent defects, right? We're talking about latent defects. You don't know about latent defects until something goes wrong. Generally, once you discover the latent defect, it's too late. So a statute of limitations doesn't work well with a latent defect. In fact, the better rule is maybe like a discovery rule. Remember with the painting. Remember the painting hanging in the guy's closet. Maybe the statute of limitations starts running when you discover the defect. Yes.
Yeah, but the thing is, especially when it comes to stuff like building houses, after a certain amount of time has passed, it just becomes too hard to determine whether it was due to an original defect in the building of it,
Or wear and
whether
tear.
it was subsequent damage, unless it's something that's really obvious, like something that's just really been poorly constructed
Okay.
and couldn't have ever been.
And okay, so here that's the second element. Merely showing a latent defect doesn't mean you win, right? You still need to show that the warranty of workmanlike quality was violated, right? It's not enough to just show there's a latent defect. That doesn't get you home. You need to show, as Zoe said, right, that there's a problem and it's the fault. The fault is from the contractor. And after 20 years with wear and tear, it's often very difficult to make that causation. This is not going to be an easy standard to justify, especially if there's a lengthy time and you were living in a house and running around and driving a car over the garage and there was rainstorms and whatever else. Okay, but Shamira, what's the key importance of dropping the privity requirement? What happens as a result of you no longer need privity?
It makes it easier to talk to the builder.
Yeah, so you can sue them, right? You get past summary judgment, you go to trial. This is the rub. In the past, a contractor could just say, no privity, I'm not even going to court. Dismiss, right? But now, you go to court in a very difficult question of fact. You have to take discovery. You have to have inspections. You have to hire a lawyer. So what the court has effectively done here is made it a lot more difficult for contractors to defend against these claims. The burden of proof is still on the homeowner. But in the past, you wouldn't have even gotten that far because all the contract would say is, no privity, you're gone. Poof. Right? No case. So the court seems assured that this is a sufficient limitation on this. That but even though you eliminate privity, it's still difficult to show a violation of this dissent. Okay. Also, a few things to stress. The court cited, by my count, 8 reasons why the common law should be abandoned, and I'll go through those fairly quickly. One, we mentioned latent defects don't appear for a lot of time. Okay. 2, I think someone said this also. Society is rapidly changing, right? Houses are sold and resold quickly, and the ordinary buyer might not be in a position to find these defects. 3, and this one makes a little bit of sense, the subsequent buyer can't inspect the construction. The person in the best position to inspect the construction is while it's happening. Okay. 4, and this one I think is a little bit of a stretch, the buyer already owes a duty. The builder already owes a duty to the first one. Why not extend it? There's no surprises there. Okay. 5. Privity might privity might encourage sham sales. So imagine this. I hire someone a really crappy job, and then I immediately sell it because I know that there won't be any liability. I don't think it's a very good reason. 6, the builder is in a better position to guard against the risk. That's usually true. 7, it's not logical to limit it to the first purchaser. Whatever. And then 8, this is something like the UCC implied warranty of fitness and merchantability. So they have all these reasons why this makes sense. Let's see. Zoe, did you notice the dissent? Who wrote the dissent?
No, I did not notice that.
Go to the very end. It's in the last paragraph of the case.
I remember that it was very short.
It was quite short.
Pretty much just said I dissent.
Who wrote it?
Trying to find it. Justice Souter.
Justice Souter. So this is David Hackett Souter. Before he was a Supreme Court justice from 1991 till 2008, plus or minus a year. He was on the New Hampshire Supreme Court. President George H.W. Bush appointed him to the First Circuit and then appointed him to the U.S. Supreme Court. It was funny because David Souter was appointed by a Republican president, and they were trying to appoint a conservative justice, and he turned out to be quite liberal, in fact, extremely liberal. And in this opinion, he's basically saying that there's no reason to get rid of the common law. So here Souter was being all conservative, saying, no, keep the common law rule. So this may have actually been one of the opinions that actually faked out the White House and made them think that he was a conservative, but he was not a conservative. Very, very bad Supreme Court selection from the Bush administration. Okay? Yes? Someone's hand? All right. Any question? Yes, sir.
You said that Texas mostly follows common law. Is there something that we follow?
No, in fact, if you look at the, there's actually a Texas citation somewhere in those strings, and Texas actually moved on to the modern law here. Virtually almost every state, I think Texas has gotten rid of this law, and now you can hold subsequent buyers can sue the contractors. So even today, this is not that bad. All right, other questions on this case? All right, did everyone get the role? I don't like having to manage it, but just make sure everyone sees it. If for whatever reason you don't get it, it'll be right here at the end of class. You come up and sign it. I really don't care if you sign it right away or later. Yes, sir. That's Joseph?
Yes. So one of the notes talks about like the Uniform Land Transactions Act.
Don't worry about it.
But in Texas, is there a warranty of suitability?
Don't worry about the ULTA. Okay, so the Uniform Land Transaction Act has not been adopted by basically any states, so don't even worry about it. Yeah, just don't ignore it. I should not even assign that note, but it's in there.
But what's this like in Texas?
Well, I think you have the duty to subsequent buyers.
And does it only apply to new work done, or does it apply to?
I mean, any work. If you're a contractor, the implied warranty stretches for the future.
Okay.
All right, other questions? Anything else? Yes, Zoe.
Yeah, I was wondering, so what kind of remedy does a buyer have if, say, a previous buyer made some changes to the house, but no one knows exactly which changes they made, and so
then
the previous buyer said that, oh, well, the contractor did that, and the contractor said, well, probably the previous buyer did that.
Okay, so what you're discussing is a very difficult question of fact, in which case probably the subsequent buyer screwed.
Yeah, it's something that actually happened to us. The house I grew up in, the guy that we bought it from had done some DIY projects, including adding a room onto the house.
Didn't turn out so well?
Yeah, we spent a lot of money fixing a lot of the stuff that apparently he screwed up, but we're not sure if all of it's what he screwed up. But I still remember that there was a whole bunch of problems with the electrical wiring, and that one add-on room to the house would flood when it rained.
Yeah, I mean, these are difficult questions of proof. And it's hard to show who did what, and usually the subsequent buyer's on the hook. Sorry. Okay, any other questions? Yes, Hugo?
I guess in response to Joey's thing, I guess the demarcation that I saw in this was latent wrong. I feel like that is the key aspect to making this whole thing work. It's not latent, and you could sue him for selling you faulty house.
Right. I mean, so presumably, if you're the first buyer and you know that you get it fixed right away. So let me ask you this question, Hugo. So say, you're about to sell your house, right? And you get some work done, and you realize it's shoddy, and you're about to sell your house, so you don't care, and you know there's a problem, and you stay quiet, you don't say anything. It's not a latent defect, but maybe it could be a defect that can be understood. And then the person buys the house and doesn't ask the right questions. Can then the subsequent buyer sue on it? Shemaya, what do you think?
No duty to disclose.
There's no duty to disclose.
But you can't just lie.
He didn't lie. He just stayed quiet.
Oh, no.
Right. So that's the situation where if it's not a latent defect and there's no misrepresentation, no lying, you're on your own. You could have done an inspection to find it. So you're right. This is mostly a doctrine for latent defects.
I think it may in Layton, there was I guess the guy before us.
Oh, you're talking about your house now, not my question.
I would ask, what if this person who made these changes knew that? What if they didn't know there was a problem? What if they thought that they fixed it and they thought they did a good job and saved a lot of money because they didn't bring in a professional?
Well, if he was aware of the problems and they were latent, then he would be obligated to disclose them. All right. Any other questions on this case? All right, let's move on. Let's do the Jones case. All right, finished everyone. Sean? All right, back up top, my friend. What happened? What happened in Jones v. Lee?
So they agreed to have a real estate contract, and actually didn't get to this case. I thought the last case.
That was the first case. Okay, we'll come back to John.
So the buyers, they put up earnest money.
Okay.
And like trying to secure that they were gonna.
Okay, so what was the purchase price?
Purchase price was $610,000.
Okay, good. What was your earnest money?
$6,000.
Okay, 6,000. Okay. All right. Then what happened?
Then they backed out.
Okay, so the buyer backs out. Okay, good.
And they pretty much came. It doesn't really go into detail with what their full story was, but they said they weren't financially able.
It was something shady sounding, right?
Yeah, just like, oh no, we can't have money to do this, so we want. They're trying to like convince the seller that they would like end the contract, or that would be the end of it. You can keep the deposit.
Right.
And seller actually did sell the house.
Okay.
For $70,000 below the $6,000 they were.
Good. Okay. All right. So here's the situation, right? Buyer makes an offer for $610,000. He puts down roughly 10% earnest money, so $6,000. Then, for whatever reason, he backs out, and he's like, oh, "You can keep my $6,000 earnest money. I don't want it back, but I'm not going to buy the house." Then they go and sell it for $540,000. So there's a difference, right? A difference of 70. So think about this for a second, just numbers, right? The buyer lost 70 grand minus the 6,000. He lost 70 grand. Had the contract gone through as it was supposed to, he would have made 610. But instead, he only made 540. Okay. So Derek. So what happened in court? What were the damages sought? Okay, so first, let's up. Had they come up with the $70,000 number? We already said this, but how did they do the $70,000 number? Okay, good. So basically, they're saying, had the contract gone through, we would have sold this for $610. Because it didn't go through, we only sold it for $540. We're seeking $70. They also saw punitive damages. We'll get to the punitive damages later. Okay. What was the problem? Catherine? Catherine, what was the problem with using the $610,000 number? Why was that problematic?
Because there was more predictable that
Let me ask you like this. What was the market value of the house? Well, look at the numbers on the board. Right? What was the market value? So you'll remember, right, in contracts, right? So the damages would be equal to the market value minus the purchase price, right? Try and figure out what the measure of damage is. Like, so what was the actual, I'm sorry, the sale price? What was the market value versus what did it actually sell for, right? So, Catherine, what was the market value there? How do we know? Why would it be 610? What do you think, Alex? How do you determine the market value of something? Here, Sean, redeem yourself. Put your hand up. How do you determine the market value?
I thought it was the eventual actual sale price. I think contracts are bigger.
Okay. So you're both on the right track. Here's the rub. The market price, I think Alex said it, is whatever someone's willing to pay for it. Okay? Your sales price may be above the market price, or more likely below the market price. Sometimes you might buy something for a steal. Maybe the seller's in a hurry and has to dump the property, so he sells it below the market price. That doesn't change what the market price is. Sometimes maybe there's a lot of buyers and they actually bid the price up above the market price. Okay? So here, you have these crooks who offered to pay $610 for the house. Do we know that that $610 was actually the market price? We don't know that. They could have just made an offer out of thin air because they weren't actually planning on following through. Who knows? Okay? So the problem is, how do you determine the market price? And actually, at a case like this, when I was clerking, it was kind of a difficult situation. It involved foreclosures in Detroit. And they were trying to figure out, what were the values of properties on an entire block in Detroit. And it's not an easy calculation. So the judge looked to newspapers. He looked to real estate listings, saying, okay, so what are these different houses listing for? Okay? Just because you know the sales price doesn't mean you know the market price. So the difficulty here is that the parties never determined what the market price was. They agreed that $610 was the purchase price. They agreed on that. That's a matter of record. But they didn't agree on what the market value is. The defendant said, you know what? The market value was always $540,000. Right? The defendant said, the market value is always $540,000. 540 minus 540 is 0. Have a nice day. You get 0. The plaintiff said, no, wait a minute, no. The market value was $610. $610 minus 540 is 70. Give us our money. So the court had to actually remand it back to determine what the market value was. Yes, John. Uh-huh.
So what does that mean? But only that on that day?
Yes. So don't follow that too closely. But the party stipulation was not actually the market value of the house in general. And this is a little bit, you're right, unclear. They effectively stipulated that was a sales price. That's what they're willing. Let me make this really precise. The $610,000 was what the defendant was willing to pay. No, what the defendant was willing to pay. That's not the market value, right? They didn't agree to what the actual market value was, and the trial judge didn't make any finding on that. And if you actually read closely, they said there was some arguing over the stipulation at court. They didn't quite agree. So the best way of understanding that is they only agreed that the defendant was willing to pay $610. They didn't do any market research. They didn't look at real estate listings. They didn't look at other documents that might indicate what a house in that neighborhood with a certain number of square footage might cost. I mean, look, you look at other houses. You ever know that Zillow.com? Right? It's this website that shows you that the house prices of houses in a given area. When I first found this, I got a little crazy. I was like, wow, that's a lot of it. But ZILLOW.com. You type in any address, and it'll show you the property value of every single house in that block. Right? And say there's a house next door, similar size, similar number of bedrooms, sold recently in the last few years for X, that's probably a good estimate. All right. So, yes, sir.
Would they take an average of, he's put the sell price at 540, he's sold at 610. Let's say that those were the only 2 periods. Would an average be a reasonable thing, I guess, a prudent thing to do for the court, or how would they go about solving that if there's not that many offers?
All right, so I'll just type in a random area of the oops. I'll just the Heights, Houston. I don't know. I'll make something up. I'll try. Okay, let's just do Houston, and we'll. Whenever I try to improvise a class, it never works, right? But I'll just try this. This will give you a sense of in a given area. You can actually find with pretty detailed specificity what nearby houses cost. Of course, this won't work. Of course, it finds the most expensive ones. 2 million and 100. Come on. It's thinking. Anyway, and I'll take another question this time while it's loading. I saw another hand. Oh, come on. I don't want to register. All right, whatever. I'll let the load when it does. All right. Other questions? Okay. So the problem was in this case they didn't actually stipulate to the market value. So they need to actually remand it to the lower court to find what the market value is. Okay? Everyone get that part? Don't worry about the, okay, here we go. Don't worry too much about the special damage. That's not very important. But let's talk about punitive damages for a second. Generally speaking, what was I up to? Is that Haley? Haley, do you remember much about punitive damages in contracts? In contracts. You ever hear about punitive damages in contracts? They're normally not. Where do you get punitive damages? Towards. And so I don't mean to cut you off, but what are punitive damages? Okay. Punitive damages, or punies, if you want to be cool, mean punish, right? Puny, punishment, right? They're meant to punish egregious conduct, okay? Generally speaking, punitive damages are awarded for torts, and usually it's intentional torts where you are grossly negligent or you did something really bad. In contracts, there are usually no punitive damages. Same for property. Historically, there's no such thing as punitive damage to property. That's not a thing, right? There's no intent. There's no like gross negligence in property. But the trial court found that there was the buyers actually attempted to frighten and intimidate the sellers. They lied about their financial circumstances. And even though they said they were broke, they had like $600,000 in their bank account with an income each month of 16 grand. Right? So they said this was sufficient to warrant punitive damages. Rare, very rare. This might be the only case all year, maybe one others, where they award punitive damages, but this is very rare. Okay. Questions on this case? Nada? Okay. All right. So, yes?
So when you say market value minus sales price there, you mean like what they had contracted to buy the house for minus market value at the time of breach, right?
No. What was the actual market value, meaning look at the real estate listings, minus the sales price? This 610 number is irrelevant. It might be useful. That might actually, in fact, be the market value. But just because someone offers by 610, that's not definitive proof that's the market value. He could have just made a very high offer off the scale. Let's look at this. Let's look at the property values changed, right? Let's say, on August 1st, right, he made an offer of 610. And then, say there was, I don't know, a hurricane, the entire neighborhood got destroyed. And then on September 1st, the value was, $530,000, right? The neighborhood just got totaled. What would the measure of damages be there? 530 minus 540, negative 10, there'd be no damages there. By virtue of this hurricane, the fraudster would have been okay. Because you have to look at what is the market value at the time the house is resold, right? If at the time the house is resold, the market value drops, then you might be out of luck.
Okay.
Here you go, hand up.
Could they still have been awarded, let's say that the house was depreciated, and they would have sold it at
You said appreciated or depreciated?
if they would have sold it at a higher price.
Okay, good. Okay, so let's try this one, right? So, you know, on August 1st, the value is 610, and then like oil strikes or whatever, and the value like goes up to like, you know, 800, right? No, 8,000, right? So then, and then what do we have? We have 800, right? Minus, I don't know. Let's say the market value then was 610, whatever, right? Actually positive. You don't have to give money back, right? So if the guy breached, and you actually made a profit off of that, you can't then sue for money because there's nothing to sue. You actually made off better by not selling it on August 1st.
Given like special damages and all that. So.
Don't worry about the special damages. So I'm talking about just purchase value. But the next case is kind of like Hugo's question a little bit, right? Where they were able to resell the house for roughly the same amount. But the issue of the earnest money came up. So in this, in the case we just did from New Mexico, the earnest money said, you know what, you can keep it, right? Because they took a loss. What happens if they make a profit? Do they still have to return the earnest money? All right, so let's do the Aisha. Okay, tell me what happened in the Kutzin case, please. It's fine, however you want. What was the purchase price? Okay.
As a deposit, but there was no stipulation in the contract that included liquidated damages. In the event that the buyer breached the contract, so he decided he didn't want to buy it, and he sued him, and he sold the house for $352,000 and $500,000. And then the trial court said that he got money in damages, and then he got money for the difference in the sales price.
Okay,
and
good.
They both appealed it, and basically, Kutzin was saying he lost money on tax gains, and he wanted to keep the deposit money, and the buyer said that he wanted to keep the deposit money because it was no contract.
Okay, good. Okay, good. So let's walk through these numbers. Thank you. That's very good. So the original purchase price, the price, or I should call it maybe the contract price would be better, was $365. He put down 10%, 36. Okay. Dude backed out, breached. He admitted, right? The sales price was $352. That's a difference, to make it easy, of $12,000, right? So the seller lost $12,000. Okay, the seller lost $12,000. But 1 second, let me put this all on the same page. But you'll recall he'd been paid $36,000. So even though he lost $12,000, the seller was a positive $24,000. Everyone see that? I'm sorry, yeah, $24,000, right? Even though the sales price dropped to $12,000, he still had the deposit which he held on to, and he made out better $24,000. Okay? So, in a way, the seller was better off because of the breach. Right? He actually made more money after the breach. He got to keep that additional $24,000. Everyone see that? Everyone get that? Okay. So, Katie, so as a matter of fairness, do you feel bad for the buyer who breached and Never actually bought the house? Tell me why. But they breached. Why did they breach? Isn't that what deposit's for?
Yeah, it's understandable. I mean, it's a contract. You have obligations.
Uh-huh.
But there is a bit of unfairness there.
Why? Okay, let me ask, is that Adam? Argue the other side. Argue in favor of the seller. Why should they not have to return the deposit?
I would argue that, well, one, I would argue that you could look at, fault based, who breached, and then you would determine.
The buyer breach. He said.
So then you argue that there was buyer breach, but then you also argue that if there was something, if you wanted that money back, you should have, stipulated it in the contract. With, like they talk about, there was no liquidated.
Good.
Such as that.
All right. So, did you cover in contracts a topic called efficient breach? I'm nodding heads. Adam, remember what that is? Efficient breach? Okay, so.
I think when there's a breach and the person who breaches is better off by breaching.
Huh? Good. Okay, good. So there are different ways of looking at a contract, right? One way to say that a contract is like holy. It's sacrosanct, right? I make a bond on my word, and we agree to something. And damn it, I'm going to do it no matter what the cost. Okay? But then there's efficient breach, right? Let's look at this case. I contract to buy a house for $365,000, and then, I don't know, my job sends me somewhere else, or I have a death in the family, I need to go move quickly. I could pay the $36,000 penalty, or I could buy the entire house. Which would be better, Kevin, dropping the penalty or actually buying a house you don't need?
Depends how you look at it. You can buy the house and then sell it again.
Okay.
If you really have to leave, then
You got to get out of there. You got to scram. All right. So let me show you this story. Actually, this is it's actually kind of a funny story. So in New York City, this is a couple of years old now. There was this massive apartment complex that was opening up. Very expensive building, right? It was things like apartments were the numbers, right? She bought a $19 million luxury apartment, right? This person put down a $5 million deposit, so almost a quarter on a $20 million luxury apartment, right? The building went bust. They never finished building it. No one moved in. This poor lady was the only one who actually had put a deposit down in the apartment. She got hooked. Okay, so here's her options. She can pay another $15 million to actually get an apartment in a worthless building, or she can just walk away and leave the deposit. Right? What's more efficient, Monica? Leaving the apartment and just letting people $15 million, or $5 million, or buying an apartment in a worthless building? Walking away. This is what we call an efficient breach, right? An efficient breach is where it's actually cheaper for everyone to breach the contract. Yeah. In that building, yes. The building was incomplete. It was not going to be completed. It was not even, actually, if you read the article, it's funny. She was complaining that there wasn't hot water, there wasn't, the floors weren't finished. The building wasn't done, so she couldn't do anything there. Yeah.
So wasn't the building owner in breach and they should have paid her back?
That's a separate issue whether she gets the deposit back, which we'll get to in a moment. But she decided, screw it, I'm not going to pay you the additional $15 million. The landlord tried to sue her for the full $20 million. He argued that the building was good enough. Okay. So here, you read this, right? The list of problems. Missing microwave grates that did not render it uninhabitable. So there were probably some other issues. So this is what the judge wrote. The judge wrote, I'll read it in case you can't see it. Campbell may have made a wise lifestyle choice to abandon her purchase. Had she closed in 2009, she would be the only owner in the building. But based on the evidence, the hotel was entitled to keep the deposit. Okay? I'll come back to our case in a minute. But in this situation, she decided to walk away, but then she tried to collect her deposit back. Okay? But here, the court said the building keeps the deposit because she made a bad decision. All right, everyone see that? That's not what happened in our case. In our case, there was a recovery, right? So is that Leda? Leda, what happened in our case on appeal?
On appeal, the court told non-petitioning party that they had to give the excess money.
Okay, why?
Because they said that they were not, like they said that they weren't allowed to, I guess, benefit from the fee.
Good. So you remember a term from torts or contract called unjust enrichment? Remember that term? Is that Victoria? What's that? You remember this term mean unjust enrichment?
It wouldn't be fair. Like if something was to, they'd be getting work on.
Right. In other words, you're not supposed to benefit from someone else's wrongful conduct, right? So in the event that this party breaches, you can't get this extra money. Okay? The court describes it almost in terms of a penalty, right? You are penalizing the buyer for breaching. You are penalizing the buyer for breaching. Now you might say, duh, isn't that point of penalties, right? Isn't that the point of damages? To punish breaches and encourage compliance with contracts. Isn't that the general rule? But we are in the 20th century, and as we saw in the last case, property and tort contract doctrines are merging, and the spirit of fairness and equity dictates either. Is that Mike? Mike, why did the modern trend, why are we not going to punish breachers? Why is it not fair in this situation to hold the penalty back?
Well, in this situation, the sellers basically running off on more money than they were actually owed off the market value of the house that's on the sale.
Good. So effectively, we don't want to give people unjust enrichment. We don't want to penalize the buyer. Is your hand up?
But would it discourage efficient breaches also?
It does. And that's why I'm not a fan of the modern doctrine. Explain why this discourages efficient breaches.
People will probably buy the useless piece of property instead of avoiding it. They're going to get punished.
Okay. So it makes people a lot more risky, right? If I know that if I buy a piece of property that turns out to be worthless, and I know a court might get me my deposit back, I'm going to be more willing to put money down on a risky piece of property, right? If I'm spending my own money and I know I'm not going to get it back, I'm going to be very conservative, lowercase c, right? Very conservative in what properties I purchase, right? So let's go back to our lady in Manhattan, right? She made a mistake by putting down a $5 million deposit on this building that was so speculative. But she got her money back. I'm sorry, but she in this case, she did not get her money back. Do you think she'll be as risky in the future? Probably not. She'll have to see a building completed before she puts down a deposit, right? Okay, but the rule we have from the New Jersey case is the exact opposite. If a buyer knows that he can get his deposit back, he'll be much more willing to throw away earnest money because then he might get it back. We have people perhaps bidding on houses that have no intent of ever actually buying, like we did in the previous case. They put down a deposit and then they walked away. Maybe they put down deposits on 2 houses because they want both, and whichever one closes first, they keep. And the other one, they say, oh, you know what? Never mind. And give me my deposit back anyway after you resell it. It's a very dangerous standard. And the court is very skeptical about this. Questions? The court also discusses liquidated damages. Zach, what are these liquidated damages? You probably did these in contracts, I guess. I mean, generally, what is a liquidated damage? What does that mean? Nothing but water. What's a liquid? Do you know what liquidated damages? No. Okay. Parsa, what's a liquidated damage? You remember from contracts? Oh, you cover these, right? I think you did. Do any of you know what this is? Liquidated damage?
It's agreed remedy.
When? When do you agree to it?
When you make the
In advance. Okay? The key to liquidated damage is in advance, or ex ante if you want to be cool. Ex ante, you agree that if there's a breach, I will pay you this amount of money. Regardless of what actually happens, you agree in advance. Yes, sir?
They differentiate between earnest money / deposit.
Same thing. Same thing. But the court basically says we don't like liquidated damages. Courts don't like liquidated damages because it takes the court out of the business of deciding how much is owed. You basically throw a huge number at someone before you sign it, and you make them pay up. All right. So in the end, the court says keeping the deposit will be unjust enrichment, and this is not valid. Okay. That was okay. So I think what was different in this case is there was probably some contractual provisions which said that they can keep the deposit. Now, let me ask this question. Sorry, let's go back to Zach. Zach, what happens if there was a provision in the contract which said the seller deposit? You'd think, huh? So usually, right, if parties contract and they say you get to keep the deposit, right? Although the court, if you read the opinion carefully, seems to say that that's not necessarily true. They seem to actually cast some doubt on whether that provision will be effective because it will be an unjust enrichment. So again, we have a New Jersey Supreme Court reversing lots of common law doctrines and even making it harder for sophisticated parties to bargain around these deals. Yes, sir?
Does it matter the percent they get to keep in liquidated damages?
That's a factor to consider. So say if it's like, you know, a very high percentage, the court might actually find that unconscionable and invalid. Remember unconscionability, your favorite William versus Walker Thomas furniture store? That actually plays in here. Actually, there's still a store in D.C. You did that case, right? The William versus Walker Thomas case? The furniture store? You didn't do that? All right, never mind. I should note that this is really a rule for residential buyers. This is not a rule for commercial buyers. Usually commercial buyers are considered more sophisticated, and if they make a deposit, they're going to be stuck with it. Okay. All right. Anything else? That's all I got. Have a great day. Enjoy the rest of your week.